All right, so picture this. You're renting a place, maybe somewhere here in sunny Orange County. You're all settled in, paying rent on time. Everything's going smooth.
Right.
And bam, out of the blue, you get this notice telling you got to pack up and leave.
Oh, yeah.
Talk about a punch in the gut, right?
Yeah, totally unfair.
Definitely not a good feeling.
So today we're going to really get into this thing called just cause eviction here in California.
Okay.
It's like this crucial shield for renters, against these unexpected move-out demands that just come out of nowhere.
Makes sense.
But what does just cause really mean in the legal sense?
Right. Good question.
That's what we're going to unpack today. We've waded through a ton of legal guides, tenant rights stuff, the kind of stuff that usually makes your eyes glaze over.
Yeah, I know those.
But don't worry, we've sifted through it all, extracted the good stuff.
Yeah, appreciate that.
Our mission today is pretty straightforward.
Right.
We want to make these core principles of just cause eviction crystal clear, easy to digest.
Sure. So you're armed with the knowledge you need if you ever find yourself in this situation. And just a quick heads up.
Yeah.
If you're renting anywhere in Orange County, Riverside, San Diego, or Los Angeles,
okay,
and you've got questions about evictions, unlawful detainer, tenant rights, that kind of stuff, you can find a bunch of helpful info at martinezlawcenter.com. All right, so let's get down to it. What's the big idea behind just cause eviction? Like, why does this even exist?
Well, the fundamental idea with just cause eviction in California, and a lot of this comes from laws like AB 1482,
Right, AB 1482.
is that landlords, they can't just evict tenants who've been living in a property for 12 months or more without a solid, legally valid reason.
Okay.
It's a big shift from the way things used to be.
How so?
Well, you see, before, once a year passed, a landlord could basically end a tenancy for almost any reason,
Oh, wow. So they had a lot of power.
Exactly. So this just cause thing, it's meant to prevent those random retaliatory or even discriminatory evictions that can really mess up a renter's life.
Right. Yeah, totally uproot them.
Exactly.
So it's all about providing that sense of security and stability for renters.
You got it. It's about letting people establish themselves in a home without that constant fear of being kicked out for no good reason.
Makes sense. So these legitimate reasons you mentioned,
Oh.
they don't just pull those out of thin air, right? There's got to be some sort of framework.
Absolutely. And that's where things get interesting. These reasons, they're neatly categorized into two main buckets, which are super important for tenants to wrap their heads around.
Okay, I'm intrigued. Lay it on me.
We got at fault, just cause, and then we got no fault, just cause.
At fault versus no fault. Okay, that makes sense. Let's start with at fault. What kinds of situations fall under that?
All right, so at fault reasons basically mean that the tenant did something or didn't do something that goes against their responsibilities as a renter.
Okay.
The most common one, the one that probably pops into everyone's mind first, is not paying rent.
Right, yeah. Got to pay the rent.
Exactly.
Yeah.
And in that situation, a landlord can typically slap you with a 3-day notice to pay or quit.
3 days. Wow, that's pretty quick.
Yeah, it is. But there's another big area that often trips people up, and it's called a material breach of the rental agreement.
Material breach. Sounds serious.
It is. It basically means you broke the rules of your lease in a major way.
Okay, so like what? Give me some examples.
Sure thing. So having unauthorized people living there, more than your lease allows.
Okay.
Or keeping pets when they're not allowed, causing a bunch of damage to the property subletting without getting the okay from the landlord, that kind of stuff.
So if I have a friend crash on my couch for a couple weeks longer than expected, I'm automatically getting evicted.
Not necessarily. Here's a key detail. The notice period for these breaches, it can vary. And sometimes you actually get a chance to fix the problem, hit the undo button.
Oh, that's good to know.
Yeah, so it's not always an immediate eviction. Some places even have a cure period.
A cure period.
Yeah, like in Santa Ana. For certain violations that can be fixed, curable ones. The landlord might have to give you a notice to fix the issue first before they can even think about evicting you if you don't resolve it.
Oh, so it's like a second chance.
Exactly, a chance to make things right. So yeah, if you accidentally have a friend overstay their welcome, you might get a chance to rectify that before facing eviction proceedings.
That's reassuring to know. It's not always a straight shot to being kicked out.
Nope, not at all. There are other at-fault reasons too, like creating a nuisance.
Nuisance? Like what? Playing loud music late at night?
That could be part of it, but it's more than just occasional noise. We're talking about behavior that truly disrupts the peace and quiet or safety of other tenants or the landlord.
Right, so like chronic issues.
Exactly. And of course, engaging in illegal activities on the property, that's a pretty obvious at-fault reason.
Yeah, no argument there.
And here's another one. If you block the landlord from legally accessing the property, like for essential repairs after they've given you proper notice, that can also be grounds for eviction.
So if I lose my keys and can't let the plumber in, that's it. I'm out.
Well, not quite. It's more about intentionally denying access.
Okay, that makes more sense.
And then there's the lease situation. Sometimes when your lease expires, the landlord might offer you a new one that's basically the same as the old one, just updated,
Right.
And refusing to sign that new lease could be considered an at-fault reason for eviction.
Interesting. So it's not just about actions. It can also be about inactions.
That's right. And lastly, intentionally damaging the property, what they sometimes call committing waste.
Right.
Or failing to move out after you've given the landlord written notice that you're leaving with. Those also fall under the at-fault umbrella.
Okay, so that covers a lot of ground. When it comes to at-fault evictions, it seems like there are a lot of different ways a tenant can run into trouble.
Yeah, there are definitely things to be mindful of. Now let's flip the script and dive into the no-fault side of things.
Okay, no fault. So we're talking about situations where the tenant hasn't necessarily done anything wrong.
Right, you got it. It's all about the landlord's circumstances or decisions, not about any fault of the tenant.
All right, give me the lowdown. What are some common no-fault reasons?
One of the most common ones you'll hear about is when the landlord or a close family member, like a parent, child, spouse, grandparent,
Right, immediate family.
exactly wants to move into the property themselves as their primary residence.
Okay, so they're not just renting it out anymore. They're actually going to live there.
Precisely. And typically they have to give the tenant a 60-day notice.
60 days. So a bit more breathing room than the 3-day notice for unpaid rent?
Yeah, definitely.
Yeah.
But it's not as simple as it used to be. There's this law, SB 567, that's added some important safeguards for tenants.
Oh, interesting. Tell me more about the safeguards.
Well, for starters, the owner or their relative, they usually have to actually move in within 90 days after the tenant leaves and live there for at least a year.
So no funny business like kicking out a tenant and then just leaving the place empty.
Exactly. They have to be serious about living there. And the notice they give the tenant, it has to include the name of the person who's moving in and their relationship to the owner.
Okay, so full transparency.
Right. And there's more. The landlord can't have another similar vacant unit on the property when they give that notice.
So they can't just shuffle tenants around for their convenience?
Nope. They got to be legit about needing that specific unit for themselves or their family member. And just to be super clear, Santa Ana, they recognize this owner or relative move-in as a no-fault reason, too.
Okay, good to know. So it's not just a state law thing. It applies locally as well. What other no-fault reasons are out there?
Another big one is when a landlord decides to pull the property off the rental market altogether.
Like they're done being a landlord.
Yeah, basically. This often happens under something called the Ellis Act.
The Ellis Act. Got it.
And again, they usually need to give a 60-day notice.
60 days seems to be the standard for most no-fault situations.
Yeah, it's a pretty common time frame. Then you've got demolition or a major remodel of the property. Those fall under no fault, too.
So if they're tearing the building down or gutting it, I guess it makes sense that the tenant would have to move out.
Right. It's not really habitable during major construction.
And is the notice period for that also 60 days?
You guessed it. Typically 60 days. But SB 567, that law we talked about, it's actually made things a bit more specific. They've defined substantial remodel more clearly, and now the landlord has to include certain details in the notice, like permits and a description of what work they're doing.
So they can't just say remodel and leave it at that.
Nope, they got to be more transparent about the scope of the work. And if a government agency orders the property to be vacated, maybe because of safety violations or something.
Right.
That's another no-fault reason. Usually comes with a 60-day notice as well.
Okay, so government orders fall under that category too.
Yeah.
Makes sense. And just to reiterate, Santa Ana, they include demolition remodel and government-ordered vacates in their list of no-fault reasons as well, right?
They do. They're on the same page as the state law on those. And here's an interesting one specific to Santa Ana. If a mobile home park is being sold and the use of the land is changing, that also requires at least a 60-day notice and a relocation plan for the residents.
Oh, wow. A relocation plan? That's interesting. I guess that makes sense considering mobile homes aren't as easy to just pick up and move as a regular apartment.
Exactly. It's a unique situation that needs extra consideration. Now, with all these no-fault situations where the tenant isn't at fault, are there any protections in place for them?
Yeah, like they're being forced to move out through no fault of their own. Do they just get thrown out on the street?
No, definitely not. There are some safeguards in place.
Okay, that's good to hear.
Under AB 1482, in most no-fault eviction cases, landlords are usually required to provide relocation assistance.
Relocation assistance, what does that entail?
It's basically financial help to help the tenant find a new place to live.
Oh, okay. So like money to cover moving costs, security deposit, that kind of stuff.
Exactly. And the amount is typically equal to 1 month's rent.
1 month's rent. That's pretty significant.
It can be a big help, especially when you're facing an unexpected move.
For sure. And this relocation assistance is required in all no-fault evictions across California.
Well, it's required under state law, but here's where things get even better.
Oh, there's more.
Yep. Local ordinances, they can actually step in and provide even greater protection for tenants.
Like how?
For example, in cities like San Diego and Santa Ana, the relocation assistance requirements might be higher.
So they might get more than just 1 month's rent.
Potentially. And in Santa Ana specifically, the landlord has to offer either 1 month's rent as relocation assistance or waive the tenant's rent for the final 3 months of their tenancy.
Wow. So they either get cash up front or they get to live rent-free for 3 months. That's a pretty sweet deal.
Yeah, it's a good example of how local ordinances can really make a difference.
So tenants in Santa Ana, if they're facing a no-fault eviction, they should definitely double-check that they're being offered that relocation assistance.
Absolutely. And here's another crucial point. If a landlord fails to provide this required relocation assistance in a no-fault eviction,
Okay.
the eviction notice itself could potentially be considered invalid.
Invalid, like it doesn't hold up in court.
Exactly. It can be a major defense for the tenant.
Wow, that's powerful information for tenants to know. Their rights are really protected in those situations.
That's right. Now, I know we've been talking a lot about general rules and state laws and local ordinances.
Right.
But are there any types of properties where these just cause eviction rules don't apply at all?
Oh, good question. Yeah. Are there any exceptions to all this?
There are some important ones to keep in mind.
Okay, hit me with them.
Under AB 1482, single-family homes are generally exempt from these rules.
So if you're renting a standalone house, you're not covered by just cause eviction.
That's generally the case, but there's a catch.
Oh, there's always a catch. What is it?
If that single-family home is owned by a corporation, a real estate investment trust, or an LLC where a corporation is a member, then it's usually not exempt.
It depends on who the owner is.
Exactly. It gets a little more nuanced in those cases. Owner-occupied duplexes are also typically exempt.
Owner-occupied duplexes.
Yeah.
So if the owner lives in one unit and rents out the other.
Right. They're usually exempt from just cause eviction rules.
Makes sense. And what about brand new construction?
Newly constructed housing units built within the last 15 years, they're usually exempt as well.
15 years. So newer buildings are generally not subject to these just cause rules.
That's the general idea. But of course, there can be exceptions to this rule, too.
Oh, boy, more exceptions. It's like trying to hit a moving target.
I know it can feel that way, but here's the most important thing to remember, and this is key.
Oh, I mean.
Many cities and counties in California, they have their own local ordinances that actually expand these protections.
Expand them. So they go above and beyond the state law.
Exactly, which means a property that might be exempt under state law could still be covered by a local just cause eviction ordinance.
So just because a property seems like it falls under one of those state-level exemptions, tenants shouldn't assume they're not protected.
That's exactly right.
Yeah.
They really need to check the specific rules in their city or county, especially here in places like Orange County.
So doing your research is essential. It's not just a one-size-fits-all situation.
Definitely not. Now, you've mentioned the importance of notice a few times.
Yeah, I know. It keeps coming up. Why is proper written notice from the landlord so crucial in all this?
It's the foundation of the whole process. It's absolutely fundamental. For any eviction at fault or no fault, the landlord has to provide the tenant with a formal written notice.
Formal written notice. Okay.
And this notice, it can't be vague or sloppy. It has to be very precise.
Precise in what way?
It has to clearly state the specific reason for the eviction and provide enough details to back up that reason.
So no beating around the bush.
Nope, straight to the point. And it has to give the tenant the legally required amount of time to respond.
Respond how?
Well, depending on the situation, the response could be paying overdue rent, fixing a lease violation, or moving out.
Right. So the notice has to lay out what the tenant's options are.
Exactly. And here's the kicker. A notice that's vague or doesn't provide enough details or it leaves out any required information, it can be challenged in court. Yeah, and potentially be deemed invalid.
So that piece of paper, that notice, is really important.
It's not just a formality, it's a legally binding document. And a flawed notice can be a crucial defense for a tenant facing eviction.
Wow, so tenants really need to scrutinize those notices, make sure everything is in order.
Absolutely, read it carefully. And there's an extra layer of protection in Santa Ana for tenancies that started after November 19, 2021.
Oh, what's that?
The landlord is actually required to include a written notice of the just cause eviction requirements as an addendum to the lease agreement itself.
So right there in the lease, they have to spell out the rules of the game.
Precisely. It's all about transparency and making sure tenants are informed from the get-go.
That's a really good example of how local rules can provide extra safeguards for tenants.
It is. It is.
Yeah.
Now, speaking of local rules, can you just remind our listeners why it's so important for them to be aware of any local just cause eviction ordinances in their city, especially here in Orange County?
Sure thing. It all boils down to this many cities in California, including big ones like Los Angeles, Oakland, San Diego, San Francisco, and crucially for our listeners, Santa Ana, they have their own just cause eviction ordinances.
Right, and these local rules, they can be a real game changer for tenants because they often offer even stronger protections than the state law.
Stronger how?
Well, they might cover more types of properties, for one thing, and they could kick in after a shorter period of occupancy.
Oh, interesting.
Like in Santa Ana, just cost protections can apply after just 30 days of living in a property.
Wow, so much shorter than the 12 months required by state law.
Exactly, and they often have different and sometimes more stringent requirements that landlords have to meet.
So landlords have to jump through more hoops?
You could say that. And they might also mandate more generous relocation assistance in no-fault eviction situations.
So even more help for tenants who are being forced to move out.
That's the idea. So the bottom line is always check the local ordinances in your city to get the full picture of your rights as a tenant.
Okay, so local rules matter.
Big time. Absolutely. And for tenants in Orange County, Riverside, San Diego, and Los Angeles who have questions about their rights, martinezlawcenter.com is a great place to start.
Perfect. All right, let's bring it all home. What's the key takeaway you want our listeners to remember about just cause eviction in California, especially if they're renting in a place like Orange County?
The most important thing to remember is this. If you've been renting your home in California for a year or more, your landlord generally needs a legally valid reason to ask you to move out.
No more arbitrary evictions.
Exactly. And these reasons, they fall into those two main categories we talked about: at-fault reasons, which are tied to your actions as a tenant,
Right.
and no-fault reasons, which are based on the landlord's circumstances.
Got it.
And both of these categories have specific rules and strict notice requirements that landlords have to follow very carefully.
So it's a system with checks and balances.
Precisely. And it's super important to be aware of any local ordinances in your city because they can often provide even greater protection than the state law.
Local laws can be a tenant's best friend.
Often they are.
And knowing all this stuff, it really empowers you as a renter.
Without a doubt.
Understanding the difference between those types of eviction, knowing how much notice you're entitled to, being aware of potential relocation assistance. It can make a huge difference if you ever get that dreaded notice to vacate.
Knowledge is power in these situations.
Absolutely. And if you're a tenant in Orange County, Riverside, San Diego, or Los Angeles, and you've received an eviction notice, or you have any questions about your tenant rights, don't hesitate to seek legal assistance. You got to understand your specific situation.
Right. Get some expert advice.
You can find more information and resources at martinezlawcenter.com.
Great resource.
Finally, think about this: understanding just cause eviction. It's not just about memorizing legal jargon. It's about recognizing this fundamental need for housing stability and fairness in the landlord-tenant relationship.
It's about having a system that works for everyone.
Exactly. And it makes us think about how these protections impact our communities and encourages us to stay informed about our rights as tenants.
Because at the end of the day, everyone deserves a safe and stable place to call home.
Couldn't have said it better myself.
Call now 714-442-9741. Thank you.